Hey, hello, my fellow property managers. Mark Cunningham, Grace Management. We talk a lot about clauses in our property management agreement. Let me share with you 3 property management clauses that I bet you do not have in your PMA, your property management agreement. Now, I got to admit, the title of this is almost a little misleading because they're not the top property management clauses. They're probably way down on the list, but they're important. That's my point. We all know the top ones. You charge a management fee. It starts here, you end there. You give me authority. I want to talk about things that are less obvious, but very, very important. 3 of them. So here we go. Number 1, service animals. Service animals. Now I'm going to give you the exact language we use in our PMA. I'm not an attorney. I'm not licensed in your state. So if you want to use this as an idea, that's fine. But run it by an attorney. Make sure this is legal in your state. This is not legal advice. Don't sue me because I'll deny you ever watched this video. Here's what we say about service animals in our PMA to our owner clients. Owner understands that state and federal law govern service animals and emotional support animals, and those animals are not legally considered pets, and therefore pet policies do not apply. I see that we forgot to put the words do not apply. It should say do not apply. Okay? Why is that important? Because owner says, hey, I don't want any pets. No pets in this rental property. You say, no problem. We'll make it a no pet property. And then you call them after a tenant moves in and they bring their service animal or their emotional support animal. And now you're like, I got to call the owner. Like, yeah, they have an emotional support cat. I told you no pets. Yeah, I know, but they have an emotional support. I specifically said no pets. And now they're mad at you. You need to be able to point back to this and say, Mr. Owner, I understand you said no pets. Remember what's in the PMA? Service animals, emotional support animals are not legally considered pet, and service and pet policies do not apply. You could even beef it up if you want to. Maybe add another sentence that says something to the effect of you, agent, will have all authority to approve or decline service animal requests, which you should anyway. That should be in there as well. So make sure you're doing that. Don't go to your owner and be like, hey, they want to have an emotional support alligator. What do you want to do? Which, by the way, there's this famous story. Google it. The emotional support alligator got approved. Like, what do you want to do? Because they'll say no. They don't know the laws. They're not the ones that are going to get sued. You know the laws. You're going to get sued. So put that in your PMA. Number 2, wear and tear. Tenant moves out of a property. Owner walks it and says, hey, I want you to charge them for these tack holes in the wall, and make sure you charge them for that little mark on the wall there where the couch was pushed up. They need to be charged for that. And you're like, Mr. Owner, these tenants have been here for 12 years, and they've always paid their rent. I can't. You charge them for that. I think it's wear and tear. Charge them for it. Well, we have a clause in our PMA that says this. Upon renting, the law recognizes the property as a business and requires the owner to expect some expenses for cleaning and maintenance as normal wear and tear while operating a rental property. Then it goes on, there's another sentence. The owner understands that some wear and tear expenses will occur and that these costs cannot be charged to a tenant, and realizes owner will incur these expenses. It's just kind of setting expectations. Hey, when the tenant moves out, Mr. Owner, everything is not back billable to the tenant. They don't have to return the property to its full condition that it was before. Why? Because wear and tear needs to be understood. So put some language in your PMA to set the expectation. Now, before I tell you clause number 3, I want to thank the sponsor for our video this month, Tenant Turner. We use Tenant Turner, and it helps us tremendously in filtering lead flow of applicants, right? We've got all of our vacant properties. We've got a ton of vacants right now. We couldn't handle it. We couldn't handle all the lead flow. We only have 1.5 leasing people in our office with a lot of properties to manage. The reason we can have small numbers of people with lots of properties to manage is because of these guys, Tenant Turner. They filter them on the front end. They're an online service that way. Applicants go through them to get questions answered about the properties, to set up showings on the property, to give feedback on the properties. It's like having a virtual leasing agent in your office, but it's pure software. Check them out. Call them up, have them give you the demo, show them what they tell them you want them to show you what they do for me, if that makes sense. We like them, we use them. That's the highest compliment I can give. Okay, number 3, clause number 3 is as it relates to attorney fees. And I mean attorney fees between you and an owner client. What if you get into a legal dispute with the owner client? Well, our PMA says this. If owner or broker is a prevailing party in any legal proceeding brought as a result of a dispute under this agreement, or any transaction related to or contemplated by this agreement. So now this is like us versus owner. This is not evicting tenant. This is us, each other. Then such party will be entitled to recover from the non-prevailing party all costs of such proceeding and reasonable attorney fees, here's a kicker, not to exceed $1,000. You get that? So in other words, hey, if we go to court against each other, the loser pays the winner attorney fees, but not more than $1,000. You say, well, Mark, why would you have that in place? And what we say to our owner clients is a couple things. Number one, Mr. Owner, like in 40 years, we've never been sued by an owner. We've never sued an owner. We're not, that will never happen. I will tell you that, because we will resolve our issues well before we would go to a court. That's just silly. But this is a keep the attorneys out of it clause, because no attorney is going to want to jump in if they're only going to get $1,000, right? This is if we have a dispute, we're going to settle this properly. We're going to settle it professionally and legally, but it's a minimizing greedy attorneys coming in and trying to run up big attorney fees so they can get a big payday. That's all this is. Now, we've had one owner one time. He refused to sign the PMA because of this. My property manager came to me and said, hey, Mark, we've got this owner client. He wants to work with us. But this clause right here, he's very uncomfortable with that. He wants that stricken. He doesn't like the $1,000 max on an attorney fee. He wants that removed, and he will agree to work this then. What do you think? I said, let me get this straight. We've got an owner client who wants to work with us. But the one thing that's keeping him from working with us, is a prohibition on us having to pay him a whole lot of money if he sues us. Like, that's the only thing he doesn't like. He's fine with everything else. But he's like, hey, if I sue you, I'm going to get a lot. I'm coming after you. I was like, no, we're not going to strike that. Are you kidding me? Like, the fact that he doesn't like it tells me we probably don't want to work with him. Send him away. Let him go work with and sue a different property management company. So consider it. I'm not saying this, you have to do this, but give it some thought and consideration. Hey, I had a PM call me the other day, and they were asking me about income. Mark, how do I make more money in property management? My profit margins are so thin. Can you give me any thoughts? And I thought, well, gosh, I mean, we've got stuff on the website. Haven't you checked it out? Oh, I didn't know you had stuff on the website. Did you know that we have something on our pmbuild.com website, which is, this is a screenshot of it there. How many income streams do we talk about? 30, I think. I don't know, 30, 25, 30 different income streams that you can provide, or that you can collect on by providing services to your owners and your tenants. So if you're struggling with your income, my friends, jump on PM Build, go into our offerings, look at the income, right? Make more money in your property management business. That's what it's all about there. You've got to be profitable, not to be greedy, but to make sure you have the profit necessary to provide the high level of service that you do to your owners and your tenants. pmbuild.com. Hope that helps, my friends. Until next month, I wish you success.